Hello, everyone. Welcome to today's Fenwick Elliott webinar. We're delighted to be back here with you again today. Thank you very much for joining us. So today, of course, we have our next adjudication update, our first of 2022. For those of you who regularly tune in to this webinar series, will know that our last adjudication update was back in October 2021. And I will put a link to, in the chat box for you as to the recording of that webinar and those slides in case you're interested. But for those who are practicing adjudication, you'll know that it's a vibrant and very lively area of construction law. And so today's session will bring us up to date since October. And as for our speakers, I'm very pleased to welcome George Boddy, a senior associate here at Fenwick Elliott, a specialist in adjudication, as well as all forms of dispute resolution in construction and energy law. And in addition, back by very popular demand following our October session, our October adjudication update, is Daniel Churcher, barrister of Four Pump Court. Daniel, too, is a specialist in adjudication, as well as all forms of dispute resolution. And indeed, he is the editor of the Adjudication Society's newsletter, so perfectly placed to take us through today's session. Now, before I hand over to the speakers in our usual way, just a few admin points. Everyone is on mute, and please do submit questions in the chat box in the toolbar that you'll see on the right, and we should have time for one or two questions at the end. And in due course, rest assured, you will see a copy of the slides and an on-demand recording of this session on our website in due course. So thank you again for joining, and I shall pass over to you, Dan.
Thank you very much, Stacey. Thank you to Fenwick Elliott for having me back. What we're going to do today, just so you know the format, is what we did in the last session, which is rather than just sort of bombard you with updates about a dozen different cases, George and I have both picked a bit of a pet topic, and we're going to do a little chat about that just to bring you up to date and let you know what we think. And then we're going to do a case law update in the second half of today's session. And I'm going to talk about 3 cases, and George is going to talk about 3 cases and bring everyone up to speed with what has been happening in the TCC over the last 4 months. So to kick us off, hybrid contracts, problems and pitfalls. Now, just to recap, many of you, all of you hopefully will know that the scope of the part of the Act which deals with adjudication is defined by reference to this idea of a construction contract, and a construction contract is a contract, quite cryptically, that is for carrying out construction operations. And we get a nice big list in section 105(1) of the Housing Grants Construction and Regeneration Act, a big inclusive list of things that are construction operations. And then in section 105(2), we get this slightly strange carve-out list, an exclusive list of things that are not construction operations. And they're things like nuclear processing, you can see there, water treatment, and relevantly for present purposes, the erection of steel in relation to power generation, for example. Now, Mr. Justice, Lord Justice Coulson, as he now is, talks in his book on adjudication about the inherent absurdity of these exclusions. And he notes in his book that it was predicted while the Act was going through Parliament that this was going to create all sorts of problems as parties debated the bounds of an adjudicator's jurisdiction. And that's exactly what happened, as we'll come on to see. But the general trend, I think it's fair to say, in relation to this definition of construction operations is to expand it. It's fair to say, I think, that the TCC is very supportive of adjudication, and in general terms, given the option to expand or restrict the boundaries of adjudication as a dispute resolution mechanism, the TCC tends to go in favour of expansion. O'Varrick and Partners, this is a good example of that sort of case. The work in question was a feasibility study for a sort of Elon Musk moonshot type project to build a Hyperloop underground tunnel underneath the Pennines to connect one side of the country to the other. Now, for reasons you might be able to guess at, this project didn't really get off the drawing board. And it was all done on a sort of exchange of emails type contract that didn't have any payment provisions or anything in it like that, or indeed any adjudication provisions. But Arup, the engineers who did this feasibility study, said, well, that's fair enough, but this is design work or advisory work in relation to construction operations. Therefore, the Act applies. Therefore, we can adjudicate and we can smash and grab for the money we want. And the other side said, come off it. This is miles away from construction operations. Not only was ground never broken, but realistically, it was never going to be broken. This was just sort of everyone getting around in a room and talking about what could be done. TCC says, nope, it is design work in relation to construction operations. Doesn't matter how far away from those construction operations you are within the Act, and you can take advantage of all the lovely payment remedies you get under the Act. Now, where it can go wrong is in hybrid contracts, where you have a scope of work that includes partly work within the scope of the Act, i.e. construction operations, partly work outside the scope of the Act, non-construction operations. And this issue came up in Cleveland Bridge and Wesso, all the parties that you see in the TCC reports all the time. And what Mr. Justice Ramsey said was, well, if the adjudicator renders a single decision, and part of that decision covers construction operations over which the adjudicator does have jurisdiction, and part covers non-construction operations and the adjudicator does not have jurisdiction, the whole decision is unenforceable. And the only circumstance in which you can get away from that conclusion is if you can say that one part of the decision, the extra jurisdictional part, can be severed from the other part. And that's not very easy, because what the court will not do is get into the nuts and bolts of the decision and start dissecting it for you and finding out which bits are within and which bits are without jurisdiction. Similar problem, right mess that the claimant gets itself into in this case. Adjudicator has given a decision covering power plant works. As you might expect, it's a hybrid contract, and the adjudicator only has jurisdiction over the construction operations portion. The TCC refuses to enforce the adjudicator's decision on that basis. So what Severfield then does, it goes away and it has a look at its adjudicator's decision, and it comes up with a new payment application. And this payment application, Severfield says, only includes the construction operations that the adjudicator found to be, or that the adjudicator dealt with in their decision. So they say that's fine. So this is all covered by the adjudicator's decision, and it's all within the scope of the Act. So we'd like summary judgment on this payment application, please. TCC, not so fast. This doesn't look at all like the dispute that you referred to the adjudicator. It may well have some overlap with the findings that the adjudicator made in your adjudication, but you can't just make a new payment application and try and piggyback a summary judgment application on the basis of that payment application on the back of your other adjudication. So not going to enforce. So what can you do if you've got a contract? And this is a real hot topic at the moment because, as I'm sure many of you have seen, there's a lot of energy from waste and similar type projects around at the moment. And these often raise these issues of, you know, construction operations under part of the contract, debatable construction operations sitting in the middle, and things that are very clearly not construction operations. So if you're a contractor and you're putting in your application and you think, goodness me, there might be a bit of a problem with this. I wonder whether some of this falls outside the scope of the adjudicator's jurisdiction. What can you do? Well, severance is not easy, but have a look at what Mr. Justice Ramsey says in Cleveland Bridge. Basically, I think what you would need to do in order to have a hope of severance is make sure that you make it very clear to the adjudicator that there are different chunks of work, and why not indeed expressly invite the adjudicator to deal with those different chunks separately, and perhaps in the alternative, you know, decide this bit if you decide your jurisdiction is this, if you decide your jurisdiction is something else, decide this bit. But that way, when you get your final decision, you should have lots of nice, neat, self-contained findings. And if the court later finds that the adjudicator overstepped their bounds on one of them, you can at least maximize the chances that you can hive that bit off and enforce the rest of the decision. So that covers cases where there's a jurisdictional problem, right? Where there is an issue about whether the adjudicator's jurisdiction covers the whole of the dispute referred to them. But there's a slightly more subtle problem that can arise where you have a hybrid contract. Because it might be that although you've got a hybrid contract, you have included an express contractual adjudication provision, which covers the whole lot of the works. And what you can imagine you will then have is an adjudication where part of the subject matter of the adjudication is within the scope of the Act and part is only covered by this contractual provision within the contract that you've agreed. And that, I think, potentially raises some interesting issues around rights of set-off. And there's a case which I think not many people have come across, but it's called Parsons Plastics, and it's a Court of Appeal case from all the way back in 2002. And what happened there was there'd been an adjudication, and the party who was successful went off and said, "I would like to enforce my decision, please." And the paying party said, well, actually, we've got all these great big counterclaims that we're going to bring against you, and they are more than sufficient in size to extinguish any liability we may have to you in relation to your adjudicator's decision. And they also say, look, we've got this express contractual right of set-off, which says that we can set off any of our claims against any liabilities that we may have to you. Anyway, the party trying to enforce the decision says, well, that's very interesting, but the contract also says you must comply with adjudicators' decisions and therefore pay up. The Court of Appeal says, no, the set-off clause trumps the adjudication clause in this particular contract. And as a result, the paying party is allowed to rely on their right of set-off and can resist payment of the adjudicator's award on that basis. Now, some of you will think, goodness me, that's not what I understand the law to be, and you'd be quite right, because of course, if that were the law, what would happen is that any employer who is supposed to be paying their contractor would just put their hand up and say, well, actually, I've got this great big defects claim lurking in the background. I think that's worth double whatever the adjudicator says I'm required to pay to you, and I'm just going to assert that claim, not necessarily prove it at that stage, but I'm just going to assert it and rely on it, and that way I'm going to get myself off the hook for paying the adjudicator's award. Now, obviously, that can't be right. Otherwise, adjudicators' awards would never get paid. And sure enough, the TCC over the years has looked at that Court of Appeal decision and gone, well, thanks, Court of Appeal. We're not quite sure that's how adjudication is supposed to work. And so there've been a series of cases effectively limiting the scope of Parsons Plastics. And where you end up, this case, MI Electrical Solutions, where the court says Parsons Plastics is only good law where you're dealing with a purely contractual adjudication. So you have a contract term which says, yes, you can adjudicate over disputes about your scope of work, but the adjudication, the subject matter of the adjudication is not construction operations. So it is a purely contractual adjudication. It doesn't have the statutory flavour. And the court said the reason for that distinction is when you have an adjudication that does fall within the Act, it would offend the policy of the Act, which, as we all know, is to promote cash flow and rapid resolution of the disputes, if a party could resist payment of an adjudicator's award by relying on a right of set-off. And so what the court said is either you interpret set-off clauses so that they're consistent with the policy of the Act, i.e. you can't rely on them in relation to adjudicators' awards, or the clauses are just straightforwardly unenforceable because they offend the policy of the Act. So how does all this relate to hybrid contracts? What if you have a contractual adjudication, a contract clause which says adjudicate over the whole lot if you want to, but then you end up with a single decision, partly covering construction operations within the scope of the Act, partly covering things falling outside of the Act. If the party who gets that decision wants to enforce it, is the other party entitled to rely on a set-off or not? Now, I think this is quite different question to the jurisdictional cases that we were looking at earlier, Cleveland Bridge and Severfield. And the reason it's different is because, of course, what the court doesn't want to do is or grant the adjudicator jurisdiction which they never had. You can't allow the adjudicator to decide a dispute which the parties never empowered that adjudicator to decide. But that's very different. When you've got an award and there's no question that that's within the adjudicator's jurisdiction, the only question is it within or without? Is it within or without the scope of the Act for the purposes of set-off? The only question is whether failing to enforce the award or allowing the right of set-off would offend the policy of the Act. And I think, in line with the TCC's general sort of expansive approach to these kind of questions, I suspect the answer is the latter, that you must enforce the awards, because otherwise the chunk of money that is within the Act isn't going to get paid promptly, because it's going to be frustrated by the right of set-off. But it is an open question, and potentially one of those nice little issues that will come up in front of the TCC at some point. So anyway, that was my little pet topic for this adjudication update. I'll hand over to George.
So thanks very much, Dan, and good afternoon, everyone. So I'm going to talk about adjudication and abuse of process. So not necessarily two concepts that you often see in the same sentence, but in the recent case of G&D Brickwork Contractors and Marbank Construction, G&D's application for summary enforcement of an adjudicator's decision in its favour was dismissed on the basis that the enforcement proceedings themselves were an abuse of process. So I'm going to take a closer look at that pretty rare case. But firstly, I'm just going to touch upon a couple of cases where abuse of process has cropped up in adjudication. And obviously, abuse of process is a concept that's well understood in the civil litigation context. But it's not a concept that features in the Construction Act or in the scheme. And for example, adjudicators aren't given the power to strike out a submission on abusive process grounds, as we all know. But notwithstanding that, parties have tried to run arguments at the enforcement stage on abusive process grounds, but they've not really been successful. So starting off with the Connex and M&J case, well, in that case, the Court of Appeal considered a submission that it was an abusive process for MJ to start adjudication proceedings 15 months after they'd accepted a repudiatory breach of contract on the part of Connex. The Connex said that delay amounted to an abusive process, and that the phrase "at any time," i.e. the right to start an adjudication at any time, couldn't be read literally. But as we all know now, that submission was rejected by the Court of Appeal, and the right to commence an adjudication at any time has been given the literal interpretation. In the Encore case, Encore and Costain sought to resist enforcement on the basis that the referral was too large. It consisted of over 5,000 pages, and Costain said that was unfair and an abuse of the adjudication process. Unsurprisingly, that argument was rejected at the enforcement stage. The judge said that the necessity to respond very quickly to large amounts of paperwork, as we all know, having been on the receiving end of adjudications, is inherent in the process. And then finally, the Lanes and Galliford Try case. Well, Galliford Try were essentially forum shopping. They served their notice of adjudication, applied to the nominating body for the appointment of an adjudicator. Nominating body appointed someone that Galliford Try didn't like, so they just let the notice lapse, didn't serve the referral notice, and then they served a fresh notice to start the process again. But when they did that, Lanes sought to injunct Galliford Try. And while Aikenhead in the TCC said that there appeared to be a lacuna in the Act which allowed the referring party to do this, and he said that clearly involved something that many might well perceive as an abusive process, he rejected the argument that Galliford Try's conduct amounted to one, and that decision was endorsed by the Court of Appeal. And in fact, in the Connex and Lanes cases, the courts both acknowledged that there is no concept of abusive process in adjudication. However, G&D, in the case of G&D, it certainly did come up, as I will explain. So G&D, just a bit of background, G&D is a brickwork subcontractor, Marbank's a main contractor. G&D had a subcontract with Marbank to carry out some brickwork on a property on Uxbridge Road in West London. The enforcement hearing, which I'll come on to later on, concerned an adjudication commenced by G&D against Marbank, seeking payment of the unpaid sum of £36,000 in connection with the Uxbridge Road project. But before G&D started this adjudication, there was a lengthy procedural history, which I'll quickly run through because it's important that we understand it in the context of the enforcement hearing in respect of the adjudication later on. So in June 2017, G&D issued a Part 8 claim in the county court seeking payment of just over £100,000 for services at 3 different sites, including the Uxbridge Road site. Obviously, Part 8 was the wrong procedure for that kind of claim. They should have issued under Part 7, and in November 2017, G&D was struck out for the first time. G&D applied to restore its claim with the correct procedure, and this was permitted by the judge, who ordered them to serve amended particulars of claim by the end of January 2018, but its solicitors failed to serve the particulars of claim on time. So G&D was struck out again. So in February, G&D solicitors applied for relief from sanctions, and G&D and Marbank agreed by consent that G&D would be given another chance to serve the particulars of claim. The claim was then stayed for ADR until October 2018, but that was obviously unsuccessful, as the matter was then, in December 2018, listed for a CMC. For some reason, the case just went off the radar for about a year, and in August 19, there was a further CMC listed for January 2020. So we're already 2.5 years down the line. Wonder whether by this time G&D was regretting its decision to start court proceedings rather than adjudication. But there we go. So witness statements were exchanged in February 2020, and then the claim was stayed for ADR for a second time until May 2020, and the order at that point, staying the proceedings for ADR, said that parties should seek further directions by the 21st of June 2020, and in default of that, the claim would be struck out. And the court at the enforcement stage assumed that this order had been made due to the extremely leisurely pace at which the case had progressed to date. But surprise, surprise, G&D failed to seek further directions from the court. And on the 27th of July 2020, the claim was struck out for a third time. G&D applied for relief from sanctions again, but this time it was refused. So for G&D, it was 3 strikes and they were out. But obviously, the court proceedings hadn't gone particularly well for G&D, so it changed tack and it started 4 separate adjudications, seeking sums on the 4 separate projects, 4 separate contracts. Quite why it didn't start off with adjudication in the first place, we don't know. Perhaps the fact that it was owed sums on 4 different contracts put it off. But anyway, it cracked on with its 4 adjudications. And Marbank decided to apply for an injunction to restrain those proceedings. It said that it was unreasonable and oppressive because the adjudications raised the same or substantially the same issues as had been dealt with in the county court, where obviously G&D had been struck out 3 times. Mrs. Justice O'Farrell refused to grant the injunction. She noted that it was only in very rare cases that the court would interfere with the adjudication process, and that the complaints that Marbank had raised were matters that could be dealt with at the enforcement stage. So the adjudication went ahead. And in respect of the Uxbridge Road project, the adjudicator awarded G&D £35,000. So unsurprisingly, G&D had to go to enforcement, and the enforcement proceedings were defended by Marbank on the basis that the proceedings themselves were an abusive process and should be struck out pursuant to CPR 3.42b. So a claim may fall within that section of the civil procedure rules where it's vexatious, scurrilous, or obviously ill-founded, but there's no sort of hard and fast definition of what may or may not amount to an abusive process. And there's, if you look at the case law under this particular rule, there's numerous different examples of abusive process that are there. So the principles that were applied by the court at the enforcement hearings were those set out in the Davies and Carillion case. So Davies was a case where the earlier proceedings brought by the claimant had been struck out for a failure to comply with an unless order. It was the defendant's submission that the second action was an abusive process. So the principles in Davies could be summarised as follows. So if the first action itself was struck out for an abusive process, the second action covering the same subject matter would also be struck out, absent any very special reason. But if the first action is struck out for a reason other than abusive process, then the second action can still be struck out. But for the second one to amount to an abusive process, then the conduct in the first must have been inexcusable. And the court in Davies also noted that the inexcusable conduct would be judged much more harshly since the developments in Mitchell and Denton in relation to relief from sanction. And the court in Davies also said that a sort of single failure to comply with an unless order wouldn't of itself be sufficient to conclude that the second action is an abusive process. And in the circumstances in Davies, the court actually declined to strike out the second action. So in the enforcement hearing in G&D, they also referred to the Arbuthnot case on the slide. And that was concerned with allotting cases an appropriate amount of the court's resources and wasting court time, and that should be taken into account when exercising the power to strike out a case. And finally, the court also referred to the comments in Cranway and Playtech, and that was to do with the stage at which the first claim was struck out. The theory being that if the first claim is struck out at a very early stage, then it's not used as much as the court resources by then, so the second action is more likely to be permitted to proceed. So in G&D and Marbank at the enforcement stage, the questions for the court were, was it an abusive process for G&D to litigate the same issues that had been raised in the county court proceedings? Was G&D's conduct in the county court proceedings inexcusable? And if yes, was there any special reason why the court should not exercise its discretion to strike out the second action? So the answer to the first question was yes. The enforcement proceedings were an abusive process, and the judge gave 5 reasons for this. So the strikeout in June 2020 was imposed after G&D had been struck out 3 times. There were lots of procedural defaults. G&D had applied for relief from sanctions following the 3rd strikeout, but they'd been unsuccessful, and the court said it just couldn't take a benevolent view in the light of this. And the fact that its relief from sanctions application failed meant that the court at that stage had considered that its failures were serious and significant, and that there was no good reason for them. The court also G&D also said, look, this was the fault. This wasn't our fault. It was the fault of our former solicitors who missed various deadlines and failed to comply with court orders. But the court at the enforcement stage decided that that didn't matter. That didn't come to the rescue of G&D. So then the second question, was there any other special reason why the court should not exercise its discretion to strike out the enforcement proceedings? Well, the court decided that there weren't any special circumstances. In contrast to Cranway, G&D had been struck out sort of 3 years after proceedings had been commenced. So by that time, an awful amount of the court's resources had been used up. Interestingly, G&D also argued that the enforcement proceedings shouldn't be struck out because the adjudication had shown that they're entitled to a substantial sum of money. The court actually acknowledged that this was an unusual position because the adjudication had already been litigated and shown that G&D were entitled to their money, and if G&D's application for summary enforcement was to be struck out, then that would result in a windfall being granted to Marbank. However, the court said that G&D should not be able to put itself in a better position than it would have been in if it had sought to bring a second set of proceedings in court simply by resorting to a procedure, i.e. adjudication under the Construction Act, that wouldn't obviously be open to the majority of litigants. And it went on to say that if its second bite of the cherry had been by way of litigation, then it would not have been able to rely on the fact that its claim had already been determined. And the court did not see why. The fact that it had been able to take advantage of adjudication under the Construction Act, that it should be in a better position than the average litigant. Put another way, the court said that it didn't see why enforcement proceedings following an adjudication should be subject to any more sympathy than would have been the case in a second action before court. And the court concluded that it was only because of the very unusual route that G&D had taken in litigating the claim that it was able to come back before court and rely on an existing award in the adjudication. So I think perhaps all along, G&D very much ought to have started its adjudications first. It seems to have got things in a muddle and the wrong way around. But I will hand back over to Dan now to start the first half of our case law update.
Thank you, George. Right, recent cases. Case number 1, Cubex. And this is an interesting case because it shows the limits of the TCC's expansive approach to what counts as construction operations. What happened here was that the claimant Cubex had been contracted to design and manufacture some doors for use in a construction project. The contract was a bit all over the place. It wasn't entirely clear what had been agreed and when. But anyway, Cubex went off and adjudicated. They said, our work is construction work. This is a construction contract, and therefore the scheme applies. They won. Balfour Beatty resisted enforcement on the basis that this was not a construction contract. And what Cubex said was, well, okay, we accept that the supply of doors itself is not construction operations. Very clear. Section 105(2)(d) of the 1996 Act, supply of components, not construction operations. But design work, Cubex said, is included, and we also designed these doors. The court did not take very long to say no, 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 because it's only design work that is in relation to construction operations. Therefore, this all falls outside the Act, therefore, unenforceable adjudication decision. The next case, Bilton and Johnson and Three Rivers. This was a case where the defendant sought to resist enforcement of an award on the basis of alleged breaches of natural justice. And as is often the case with natural justice challenges, I think it's fair to say this was a bit of a Hail Mary attempt to resist enforcement. So the first issue of natural justice which arose was that the defendant said the adjudicator had made a finding which was not what either party had contended for. And what they said in effect was this was an example of what we call the adjudicator going off on a frolic of their own and coming up with their own answer to the problem. And the reason that is relevant to natural justice is that it said if the adjudicator does that, it deprives the parties of an opportunity to make submissions about what conclusions the adjudicator is proposing to make. And what happened here was, in effect, one party said that the contract was formed by this particular communication. The other party said, no, it was later and it was formed by this particular communication. And what the adjudicator said was, well, actually, I don't think either of you are right. I think there was one contract formed initially, and then that contract was superseded by a subsequent agreement. And that's the basis on which I'm going to find the dispute. And it was, as I say, the defendant said, well, that's not what either of us argued. The adjudicator has gone off on a frolic of his own, and therefore the decision is unenforceable. And the court said no, because what had actually happened here, it's right that the adjudicator didn't agree with either party about how this contract came into existence, but the conclusions the adjudicator did adopt were unquestionably derived from the submissions the parties had made. And looking at it in the round, there was no real question that both parties had had an adequate opportunity to set out their case on contract formation, and there was nothing wrong with the adjudicator's decision on that point. The second ground was an alleged failure by the adjudicator to properly consider an issue raised by the defendant on rectification of a particular term. And in a masterful piece of judicial understatement, what the court said about that was, this complaint proceeds from the unpromising starting point that the adjudicator's decision contains a section entitled rectification, which spans 21 paragraphs and more than 4 pages in total. Unsurprisingly, that ground of challenge also rejected by the TCC. Finally, this case, John Graham Construction and Technicas, quite an interesting factual background to this. What happened was that the parties had an adjudication where they were arguing about the contractor's scope of work. And the contractor succeeded in that adjudication, which meant that various bits of work which the defendant said it had to do, it refused to do. And then it said, well, actually, we've got nothing left to do, so we're leaving site. And the defendant, as you might expect, engaged another contractor at significant expense to complete the remaining works. The defendant wasn't happy with the adjudication decision as to the scope of work under the contract, so they went off and arbitrated the dispute. And in the arbitration, the defendant was successful, and the arbitrator found that adjudication 1 was wrong, and actually the scope of work, broadly speaking, was as contended for by the defendant. There was then another adjudication, adjudication number 4, which related to the correct value of a particular payment application. And the defendant resisted that in part based on a contracharge relating to the additional completion costs that the defendant had incurred after the claimant left site. And the claimant said, well, you can't bring that contracharge because at the time we refused to do this work, and at the time we left site, we were acting in full compliance with adjudication number 1, or the decision in adjudication number 1. And that decision was binding on the parties unless and until it was overturned in court. And the defendant said, no, 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 that's not how this works. When adjudication decision number 1 was overturned in the arbitration, what that really meant was that adjudication decision number 1 had always been wrong. And thus you were always in breach of contract for refusing to carry out the full scope of work. So this goes to court on enforcement. And what the adjudicator had said about this was the first partial award, although reversing the decision in adjudication number 1, cannot, as a matter of fact, have a retrospective effect on the lawfulness of the subsequent actions of the parties, because the parties were obliged to give effect, albeit temporarily, to that decision. Neither should be penalised for doing so. So, gets to the court, and what the defendant says is, well, this is all a bit unfair, because I won my arbitration, adjudication 1 was wrong, and I should be entitled to the contractual consequences of that. And the court decided the point by looking at what was actually decided, really getting into the nuts and bolts of what was decided in the adjudications and in the arbitration. What the court said was, the arbitration was a dispute about scope, but there was no dispute there about the financial consequences that would flow from the arbitrator's findings on the correct scope of work. Adjudication number 4, by contrast, was about financial consequences, and there was no obvious or on its face overlap between the two sets of issues. That doesn't mean that the adjudicator in adjudication 4 is not bound by the findings in arbitration 1, but it does mean the adjudicator is entitled to look at the dispute about financial consequences and reach their own conclusions. And what the adjudicator had done here, the court found, they'd actually trod quite a careful path, because what the adjudicator had done is say, well, I agree with arbitration 1 about the scope of work. I'm not going to attack the findings there, but I'm going to make a finding on causation, which is that the reason the defendant went away and got a replacement contractor was not the claimant's refusal to complete the scope of work. It was the defendant's belief that adjudication number 1 was binding. Now, that was a mistaken belief, but what the adjudicator said was, as a matter of causation, that's the answer, and therefore you can't bring your contra charge, Mr. Defendant. And the court said that might be right or wrong as a matter of law. Doesn't matter, because as we all know, an adjudicator is entitled to make mistakes in their findings so long as those mistakes are within jurisdiction. So we're not going to disturb this decision in adjudication 4, and that decision is fully enforceable. Those are my cases, and I'll hand back to George.
Thanks very much, Dan. So the first case I'm going to talk about is Brave Join and Prosperity Mosley Street. So this is a no dispute argument, type argument. PMSL, Prosperity Mosley Street, tried to resist the enforcement of the decision on the basis that the adjudicator lacked jurisdiction because there was no dispute as no contract existed between the parties. So just briefly on the background, Brave Join was originally engaged by another company to carry out some works at a development on Mosley Street in Birmingham. That other company went into liquidation, and then Brave Join alleged that it was subsequently engaged directly by PMSL. And a dispute arose in relation to a series of payments claimed by Brave Join for the work that it had carried out in connection with the project. Now, Brave Join rendered invoices to Prosperity Developments rather than the defendant company, Prosperity Mosley Street. And the way it did this, it sent them by email to an individual called Mr. Hay. So Mr. Hay had a Prosperity Developments email address, and he was acting on behalf of Prosperity Developments generally, but Brave Join said also the Prosperity Mosley Street entity. Now, what Mr. Hay did when he received these invoices, he acknowledged them, and he also issued payment certificates and pay less notices against them. And those documents included references to Mosley Street. They also included references to PMSL, i.e. Prosperity Mosley Street Limited, and was signed by Mr. Hay for and on behalf of Prosperity Mosley Street Limited. However, PMSL didn't pay all of the invoices rendered by Brave Join, so Brave Join referred the matter to adjudication. The adjudicator found that there was a contract between Brave Join and Prosperity Mosley Street, and that Prosperity Mosley Street was liable to pay Brave Join just under £40,000 pursuant to those invoices. PMSL didn't pay, obviously, and Brave Join had to enforce the decision. The PMSL sought to resist the enforcement on the basis that the adjudicator had lacked jurisdiction to make the decision, as there was no contract between it and Brave Join, and because Brave Join's invoices had been issued to another entity in the Prosperity Group other than PMSL, and that meant there was no crystallised dispute between Brave Join and PMSL. And the other ground, which was a bit of a Hail Mary ground, to be honest, as well, was that PMSL should not be liable to pay the sums claimed by Brave Join, as there were issues with Brave Join's design of the subcontract works. So the court, in making its decision on this one, reviewed the well-established case law on the meaning of whether a dispute is crystallised, which I'm sure will be familiar to many of you. key cases that are most often referred to. I've put up on the slide there, and just by way of a recap, of the principles. So the word dispute is to be read literally and should be given no special meaning. And the test for whether a dispute is crystallised is whether the claim has been made and whether that claim is disputed. It might be a claim for payment, but it can just be an assertion of a right. And it can be expressly rejected or just ignored. And inactivity by the receiving party is enough, and the length of the time the length of the inactivity before the dispute is said to have crystallised, well, that depends on the surrounding circumstances. So the question for the court at the enforcement stage was there a crystallised dispute? And the answer was yes, yes there was. As we know, it doesn't take much. It's a pretty low bar to have a crystallised dispute. It doesn't take much. And the fact that the invoices in this case had made reference to Prosperity Mosley Street, it was clear that that entity and not any other it was clear that it was that entity with whom Brave Joint had a contract. PMSL had also served its payment notices and its pay less notices against Brave Joint's invoices, and those documents made express reference to Prosperity Mosley Street. And the court said essentially that there could be no explanation for the non-payment of Brave Joint's invoices other than the fact that PMSL disputed liability for them. And PMSL had also argued in a letter from its solicitors that it didn't have a contract with Brave Joint, and it asked Brave Joint to sort of particularise the basis of its contention that there was a contract between Brave Joint and Prosperity Mosley Street. And it was clear from this letter that sent by PMSL solicitors that there was a dispute, because it could be inferred from that there was a clear denial of liability to pay the invoices. And the second ground, the Hail Mary ground for resisting enforcement, also obviously failed. That went to the substance of the issues in dispute itself, and weren't something that would be considered at the enforcement stage. So the next and the final case in our adjudication case law update I'm going to talk about is RHP Merchants and Treforest Property. So in this case, the defendant, Treforest, applied for a stay and strikeout of Part 7 proceedings brought by RHP on the basis that RHP had failed to comply with a court order enforcing an earlier adjudication decision. So in this case, this is a clear breach of the principle we always hear about: pay now, argue later. RHP had started the argument before they'd made the payment. So just by way of a bit of background, Treforest engaged RHP in connection with the development of a block of 62 residential units in Newport. In the first adjudication, RHP referred its final account claim, which it lost. The adjudicator ordered RHP to pay Treforest £260,000, and that decision was then successfully enforced by Treforest. Shortly after that enforcement hearing, RHP started a second adjudication regarding its liability for defects, and that was successful. The adjudicator ordered Treforest to pay RHP the sum of £220,000. Treforest had obviously challenged the jurisdiction of the adjudicator in connection with that adjudication, because given the fact that adjudication 1 concerned RHP's final account, it certainly appeared that the second adjudication dealt with the same or substantially the same issues that had already been decided. But obviously, even after both adjudications, there was a net sum still due to Treforest, and so RHP commenced Part 7 proceedings seeking a final determination of the parties' dispute. So this was RHP starting the argument with Treforest before it paid. In response, Treforest applied for an order that the Part 7 proceedings be stayed until RHP paid the adjudication judgment sum in respect to adjudication 1. And then if it didn't do that within 6 months, its Part 7 proceedings should be struck out. So RHP actually offered to pay Treforest the net difference between the two decisions, but that offer wasn't accepted. So in support of its argument, Treforest relied on the case of Anglo-Swiss and Pacman Lucas. And in that case, the court ordered a stay of proceedings on the basis that the claimant had refused to comply with an earlier adjudicator's decision. The court noted that such stage could be granted where justice required them, but only in rare cases, and where the claimant was obviously acting in bad faith or had been demonstrating unreasonable or oppressive conduct. RHP said that the proceedings should not be stayed, but if the court was minded to grant a stay, then it should only do so pending the payment of the balance between adjudication 1 and adjudication 2. So the decision. So the court had to balance, in making its decision, the court had to balance the principles of access to justice. In other words, RHP's right to commence Part 7 proceedings, seeking a final determination of the parties' disputes without having a stay imposed. And the court had to balance that with the construction act principle, pay now, argue later. In other words, Treforest's right to have payment of the sum that the court had enforced in respect of the first adjudication. So the court decided that the pay now, argue later principle applied to both adjudications. This is notwithstanding the fact that the first one had been enforced, the second one hadn't, and the fact that the judge at the enforcement hearing, at this particular hearing, expressed considerable doubts as to whether the adjudicator in the second adjudication had jurisdiction, as I mentioned earlier. But the court found that RHP was not guilty of any sort of bad faith of the kind that was found of the claimant in Pacman Lucas. And the court found that RHP's actions were entirely consistent with a party that just simply disagreed with the adjudicator's decisions and wanted to go to court to overturn them. So what did the court decide? Well, in the end, the court decided, the court ordered a stay of proceedings until RHP paid Treforest the net difference between the two adjudicators' decisions. And RHP was required to make that payment within 28 days, otherwise its proceedings would be struck out. And the rationale for that was the court said that if RHP paid that amount, and then it would be entitled to crack on with its Part 7 claim, and that would show that RHP hadn't brought the proceedings in bad faith. So I'll hand back over to, I'll hand back over to Stacey, but if there are any questions, then please fire away.
George, Daniel, thank you very much for taking us through that. That's been a very thorough and clear run through, bringing us up to speed since October, which has been brilliant. Time for questions, and in fact, I think it was so clear that we've just had 2 questions, which is perfect considering the timing. So I think we can take both of those if that's okay with you two. George, I think perhaps the first question might be directed to you, as it has to deal with the G&D case. Question: in the G&D case, do you think Marbank's application for an injunction to restrain the adjudication should have been successful?
Well, I think, as we know, there's a long-standing principle that it's not appropriate for the court to interfere in the adjudication process unless there's sort of unreasonable and oppressive conduct. But in this particular case, by the time we got to enforcement, both parties had presumably incurred a load of costs, irrecoverable costs on the adjudication, and the G&D's case on the enforcement proceedings. So perhaps it might have served the parties a bit better if the adjudication had not been sort of allowed to continue at the injunction stage. It was actually, the court asked themselves the question at the enforcement stage, had the adjudication been an exercise in futility because enforcement was refused, and the court, I think the court answered that question by referring to the comments of Lord Briggs in Bresco case in the Supreme Court, where it said that adjudication without enforcement was still a useful exercise, and what Lord Briggs' comments were also actually picked up by Mrs. Justice O'Farrell at the injunction stage. But it's not really clear, it's not necessarily clear to me what purpose the adjudication served, given that it was ultimately unenforceable. That raises the wider question, I think, of whether an adjudication is ever a useful exercise if it can't be enforced. Perhaps, I think Mrs. Justice O'Farrell was thinking that that kind of issue could be decided at the enforcement stage, and perhaps Marbank could have won, or maybe the parties could have done a deal halfway through, meaning that that adjudication would still have been useful. But clearly, in any event, a careful balance needs to be struck between allowing adjudications like this to continue and the court interfering too heavily in terms of injunctions.
Perfect. Thank you, George. That's time for the last question, I think. Not necessarily related to particularly some of those cases you've mentioned, but obviously very topical point here. There's been a lot of talk recently about the changes to the rules in litigation about witness statements. Now, given the much shorter time periods in adjudication, do you think there's still place for witness statements and evidence in adjudication? Either Dan?
Should I take that? I mean, I think the first thing to say about that is I think everyone has grossly underestimated the impact that the new practice direction on witness statements is going to have. And I suspect within the next 6 months, we're going to start to get the first of the angry judgments about people not having done what the practice direction requires, because it really is quite involved, and it's a very, very different process of taking evidence to what we're all used to. And I think it's fair to say that most of the witness statements you see in adjudications are precisely the sort of witness statements that the new practice direction is trying to avoid, i.e. statements which aren't focused on the issues, which aren't really focused on what the witness saw, heard, did, but are just a vehicle, often written by lawyers, in adjudication in particular, because you don't have time to take a proper proof from a witness. And more often than not, they just descend into slanging matches where the employer's PM or QS or whatever says, you're a bunch of shysters who are trying to get money out of us, and the contractor says, you're a bunch of shysters who don't want to pay us. And it just goes on and on and on, and no one really cares. So I think there is still a role for witness evidence in adjudication, but the practice direction coming in ought to be a learning point for all of us, I think, to focus witness evidence in adjudication on what really matters. And I think there are some things where an adjudicator really does benefit from witness evidence from someone who was involved in the project. For example, I went round the site and I did a measure of all of the plasterboard that had been put in, and this was how I did it, and here are my photographs. That sort of explanatory stuff where it actually matters what the individual did or saw or witnessed, great. Love that sort of evidence, and long may it continue. But your general, you're a bunch of shysters, no you are type witness statement, I wouldn't be too sorry to see the back of that, to be honest.
Super. Thank you, Dan. I think we will end on shysters, and there's nothing more for me to do but to say thank you very much to our audience for listening, and to market our next webinar in 2 weeks' time, which we have. So today we had a very domestic UK focused adjudication update. 2 weeks' time, we're reaching out to our international practice, and we will be discussing investor-state disputes and arbitrations and some upcoming amendments to those rules which govern those, and where we have our partner Nicholas Gould and Senior Associate Sana Mahmoud, who is going to take that webinar for us. So we very much hope that you can join us in 2 weeks' time for that. But thank you again to the audience for being with us today, and George and Daniel, thank you again. So I hope where everyone is at, you're staying safe and keeping well, and we hope to see you again sometime soon. Thank you very much.
Thanks, everyone. Bye-bye.